Hi. Good morning, everyone. My name is Kristen O'Neill. I am the Assistant Director of the New York State Committee on Open Government. We'll be talking today about the updates to the recent updates to the Open Meetings Law that relate to the use of video conferencing under extraordinary circumstances. So we're going to talk about how video conferencing is allowed to be used as it has always been permitted to be used, even pre-pandemic, and then how this recent amendment allows for certain additional use of video conferencing in extraordinary circumstances. So that will be our focus today. If you have questions as we go along, you're welcome to enter them into the chat feature. I will answer the questions at the end of the program. And we just want to make sure that everything is working properly. I think we're good. So to get started, this is my contact information. Again, my name is Kristen O'Neill. I'm the Assistant Director. That's my email address. If you have questions, you're welcome to contact me directly at the end of the PowerPoints, which are, by the way, available on the Committee on Open Government's website. You'll see up on the screen right now, you see our phone number, you see our website, so www.opengovernment.ny.gov is our website. If you go to our homepage and scroll down a bit, you will find a link to my training materials and recordings. So all these training programs that I've been doing for the past year and a half, I tend to do them about once a month if possible, alternating between the Freedom of Information Law and the Open Meetings Law. Recordings of all those programs are available on our YouTube page, which is accessible from our opengovernment.ny.gov page. So if you're looking for copies of this PowerPoint, it is on our website. The New York State Open Meetings Law is codified in Public Officers Law, Article 7, Sections 100 through 111. And you don't need to worry about that too much because the easiest way to find a copy of the statute is by looking directly on the opengovernment.ny.gov website. We always provide an up-to-date version of both the Freedom of Information Law and the Open Meetings Law on our website to make things easier for you. So I'm going to do a little bit of background right now on the use of video conferencing over the past 2+ years. So right now, a law that is still in effect is Chapter 1 of the laws of 2022. On January 14th of this year, Governor Hochul signed into law Chapter 1 of the laws of 2022, which amended Chapter 417 of the laws of 2021, which had authorized any public body, as the term is defined by the Open Meetings Law, to meet and take such action authorized by law without permitting in-public, in-person access to the meetings, and it authorized such meetings to be held remotely by conference call or similar service, provided that the public has the ability to view or to listen to such proceedings and that the meetings are recorded and later transcribed. So that is a law that is currently in effect. I just realized I forgot to update this slightly. We'll get there. The language of both Chapter 417 and Chapter 1 substantially mirrors the executive orders that were issued by former Governor Cuomo in March of 2020 and were repeatedly extended through June of 2021. And so at the time that those executive orders were issued in spring of 2020, the Committee on Open Government issued a number of advisory opinions relating to the use of video conferencing under those executive orders, or not even necessarily video conferencing, but remote access for the public and for the board members. We prepared advisory opinions. They are posted on our website under the key phrase, declared disaster emergency. So if you're looking for those advisory opinions, go to the section of our website under Open Meetings Law Advisory Opinions, and then scroll down to the key phrase, declared disaster emergency, and you'll find advisory opinions that relate both to those executive orders and also to Chapter 417 and Chapter 1, because the language of all of those things are all pretty much the same. What's important to keep in mind is that Chapter 1 will expire when the state's declared disaster emergency, which was issued pursuant by Governor Hochul, pursuant to Executive Order 11, expires. Right now, I realized I forgot to update this a couple days ago. It was set to expire July 14th of 2022. Governor extended it once again, so right now it is currently set to expire on August 14th, 2022. So I apologize for that mistake in my PowerPoint. So right now, Chapter 1 is in effect through August 14th, 2022. The thing to keep in mind is to pay attention to is whether the declared disaster emergency continues to be extended. Every time it's extended, the declared disaster emergency extended, Chapter 1 is also extended. So Chapter 1 is permissive. It allows for remote meetings but does not require them. If a public body wishes to have completely in-person meetings with all of their board members present in the room and opening their meetings to the public in person, it is under no obligation to provide a remote access option. On April 9th of 2022, Governor Hochul signed Chapter 56 of the laws of 2022. So this was part of the New York State budget for the 22-23 state fiscal year. So included in the budget bill is an amendment to the open meetings law to make it permanent until July 1st, 2024, the expanded use of video conferencing by public bodies to conduct open meetings under extraordinary circumstances, regardless of a declaration of emergency. As a threshold matter, it is our understanding, based on conversations with the governor's office, that the new law was never meant and is not meant to change or curtail what has always been required and permitted, required of public bodies and permitted for public bodies when complying with the open meetings law. Public bodies may continue to operate now as they did before the onset of the pandemic in early 2020, when the in-person aspects of the open meetings law were first suspended. In other words, we believe that if a public body was permitted to do it before the pandemic, this law does not change that. This law is intended to expand, in limited extraordinary circumstances only, the ability of public bodies to meet using remote access technology. This 60-day grace period that was included in Chapter 56 is at this point somewhat irrelevant because that 60 days has already come and gone. But when the law was passed in April, it included a 60-day grace period that essentially said public bodies don't need to comply with this new section of the open meetings law for another 60 days. The law was passed on April 9th, which would have brought us through June 8th, so that 60-day grace period has come and gone. But the language that was included in that grace period, again, was substantially similar and closely modeled the language of Chapter 417 and Chapter 1 of the laws of 22, which allow for remote access. I'm going to ask people that have cameras on to turn off their cameras if possible, just because sometimes when you turn your cameras on, it blocks the screen. It creates an image that overlays the PowerPoint and blocks the screen. So if you do have your cameras on, if you could turn them off, that would be great. Committee on Open Government has prepared a series of questions and answers regarding the new video conferencing amendments, and they're available here. I say here because if you go to this PowerPoint that I have that is posted on our website, that's linkable. In addition, if you go to our homepage, you're going to see right at the top of our homepage that we have a series of questions and answers regarding Chapter 56. In addition to having questions and answers regarding Chapter 56, we also drafted model resolutions, a model resolution and a model policy for the use of video conferencing in extraordinary circumstances. So if you're a municipality that is looking for something to model your resolution or policies on, we do have something available on our website. So there are two ways to use video conferencing technology to conduct an open meeting. The first way is the way that is always, well, I shouldn't say always, but that has been available for quite some time. Pre-pandemic, there was any public body that wished to connect multiple in-person physical locations to the use of video conferencing were allowed to do so. So that's one way of using video conferencing. And the example that I'll use here is the Committee on Open Government itself. We are an 11-member body, and people that are appointed to the Committee on Open Government live all over the state of New York. So in an effort to try to make attendance a little easier for these people that live all over the state of New York, we established 3 different physical locations in Department of State offices. So we have a location in Buffalo, a location in Albany, and a location in New York City. And then we would use video conferencing technology to connect all 3 of those physical locations. Each of those locations would be open to the public. It would be included in the meeting notice. So that's what has always been permitted under the open meetings law, at least for quite some time pre-pandemic. The second way to use video conferencing technology to conduct an open meeting is this new amendment to the open meetings law that went into effect in April of this year. And that's where a public body will allow one of its members to participate from a private location, a location that's not open to the public and that is not included, where the address of the location is not included in the meeting notice. So under Chapter 56, a public body may allow one of its members to participate from a private location through video conferencing, but only under extraordinary circumstances. So a public body is using the first type, sorry, I have a typo there, of video conferencing, where you're connecting multiple physical locations that are open to the public. The new Section 103A of the Open Meetings Law does not apply. Chapter 56, which added Section 103 to the Open Meetings Law, does not apply if the public body is using the first type of video conferencing that I described. Section 103A of the Open Meetings Law, which is the new language that was added by Chapter 56, states that a public body may, in its discretion, use video conferencing to conduct its meetings pursuant to the requirements of this article, provided that a minimum number of members are present to fulfill the public body's quorum requirements in the same physical location or locations where the public can attend, and then the following criteria are met. So the important thing that this language represents is that a public body must have a quorum of its members present at locations that are open to the public. So let's say you have a town board that has 5 members, and 3 of those members have asked to use video conferencing under extraordinary circumstances. The public body is not going to be able to allow that, because you need to have a quorum of the public body present at a physical location that is open to the public. The town board that has 5 members is going to need to have at least 3 members physically present at a location or locations that are open to the public. The law requires that the governing board of a county, city, town, or village must adopt a local law, and any other public body must adopt a resolution. Senate and Assembly must adopt a joint resolution. All public bodies are required to have a public hearing prior to adopting the local law or resolution, authorizing the use of video conferencing for itself and its committees or subcommittees, or it can specify that each committee or subcommittee may make its own determination. The law states that New York City community boards can make their own determinations. The law states that the public body must establish written procedures governing member and public attendance consistent with this section, and the written procedures shall be conspicuously posted on the public website of the public body. Members of the public body must be physically present at any such meeting unless such member is unable to be physically present at any such meeting location due to extraordinary circumstances as set forth in the resolution and written procedures adopted pursuant to the Open Meetings Law. Then the law goes on, Chapter 56 includes examples of what it considers to be extraordinary circumstances. It says including disability, illness, caregiving responsibilities, or any other significant or unexpected factor or event which precludes the member's physical attendance at such meeting. Every public body is permitted to define extraordinary circumstances as they deem appropriate, but in our opinion, it should probably include at a minimum the examples that are provided in the statutes. Except in the case of executive sessions, the public body shall ensure that members of the public body can be heard, seen, and identified while the meeting is being conducted, including but not limited to any motions, proposals, resolutions, and any other matter formally discussed or voted upon. So that what this means is that as opposed to Chapter 1 that is in effect right now, Chapter 1 only requires that members be heard. If someone's participating through remote access, it could be through teleconference, or it could even be through video conference with their cameras turned off. However, Chapter 56 requires that video element. It requires that the members be heard, seen, and identified. What this also means is that every member of a public body should have some way of identifying themselves. If they're sitting in a large room, and they're there in person, perhaps they should have placards in front of them identifying themselves. If they are the one participating via video conference under extraordinary circumstances, they need to enter their full names in the screen so that members of the public know who's speaking, know who's appearing on the camera. The minutes of the meetings that involve extraordinary circumstances video conferencing shall include which, if any, members participated remotely and shall be available to the public pursuant to Section 106 of the Open Meetings Law. So in addition to all the other standard requirements of relating to preparation of meeting minutes that already exist in the Open Meetings Law, those minutes must also include a statement of which members participated remotely. If extraordinary circumstances video conferencing is used to conduct a meeting, the public notice for the meeting shall inform the public that video conferencing will be used, where the public can view and or participate in such meetings, where required documents and records will be posted or available, and it must identify the physical location for the meeting where the public can attend. So if, in addition to the normal, basically right now what is required under the Open Meetings Law is date, time, and physical location. In addition, the notice must also include, for example, a link or some sort of instructions for how the public can view the video conference. Public body shall provide that each meeting conducted using extraordinary circumstances video conferencing shall be recorded, and such recordings posted or linked on the public website of the public body within 5 business days following the meeting, and shall remain so available for a minimum of 5 years thereafter. Such recordings shall be transcribed upon request. The current statute, Chapter 1 and its predecessors stated that remote meetings must be later transcribed. Chapter 56 merely states that recordings shall be transcribed upon request. So this is a new requirement in terms of posting recordings. The existing statute does not require that the recordings of the meetings be posted. This new law does require that recordings be posted within 5 business days, and they must remain available for a minimum of 5 years. I know personally the Committee on Open Government uses YouTube sort of as a storage site for our meetings. We provide a link to our YouTube channel on our website, and then people can go to that YouTube page and see meetings for past many years of the Committee on Open Government. If extraordinary circumstances video conferencing is used to conduct a meeting, the public shall provide the opportunity for members of the public to view such meetings via video and to participate in proceedings via video conference in real time where public comment or participation is authorized. It shall ensure that video conferencing authorizes the same public participation or testimony as in-person participation or testimony. So this is a new requirement as well. As many of you may know, the open meetings law in the past has been completely silent with regard to public comment and public participation. It doesn't require that public bodies offer a time for public comment or participation, and that remains true. No public body is required to offer public comment or participation. But what this new language states is that if you're going to allow the people that show up in person to your meetings, that are physically present at your meetings, to have a time to offer public comment or public participation, you have to provide that same opportunity for individuals that are participating via video conferencing. Chapter 56 says that a local public body that elects to utilize video conferencing to conduct its meetings must maintain an official website. I think the reason why they focused on this is most state agencies and most larger entities already have a website. However, there are a few small local public bodies, whether it's a small town or a village or even some other smaller entity like a water district or a sewer district, that don't have websites. But in order to take advantage of the benefits of this extraordinary circumstances video conferencing, you have to have a website, because the law requires that if you're going to allow your members to participate via video conferencing under extraordinary circumstances, you then need to post your meetings or a link to your meetings on your website. So now this is a new requirement for some entities that may never have had a website in the past. If they want to take advantage of this new provision, we're going to have a website. The language of the statute says the in-person participation requirements of Section 103A(2)(c) shall not apply during a state disaster emergency declared by the governor or a local state of emergency proclaimed by the chief executive of a county, city, village, or town if the public body determines that the circumstances necessitating the emergency declaration would affect or impair the ability of the public body to hold an in-person meeting. So what this essentially says is that if there's a state of emergency, whether it's statewide or local, a public body could, in essence, go back to having fully remote meetings regardless of extraordinary circumstances for the time that the state of emergency is in effect, but only if the public body determines that the circumstance necessitates the emergency declaration would affect or impair the ability of the public body to hold an in-person meeting. Section 103A sub 4 states that no later than January 1st, 24, the Committee on Open Government must issue a report to the governor and the legislature concerning the application and implementation of this amendment, and we must make any further recommendations governing the use of video conferencing by public bodies to conduct meetings pursuant to this section. At this point, I'll make my PSA asking public bodies, as they actually start using this provision of law. I'm not really looking for public bodies to express their concerns about what might happen. We all have concerns about what might happen. But what I would like to get is feedback from public bodies and the public generally about what has actually happened. Has this worked well? Has this been a good opportunity for additional participation by individuals that maybe might not otherwise be able to participate? What problems have you experienced? I would just ask that you notify us through our office email accounts of any comments, concerns that you have, and we will track those concerns and we can bring them to, when we prepare our report, we can take them into consideration as we prepare our report to the governor and the legislature. The law states that open meetings of any public body that are broadcast or that use video conferencing must use technology to permit access by members of the public with disabilities, consistent with the 1990 Americans with Disability Act and its corresponding guidelines. For the purposes of this section, disability shall have the meaning as defined in the New York State Executive Law, Section 292. Just so you all know, our office cannot provide legal advice regarding compliance with the Americans with Disabilities Act. That is something that you're going to need to consult with your own legal counsel regarding. We can't offer an opinion as to whether something is or is not compliant with the Americans with Disabilities Act. It is not our, we have not been given the statutory authority to provide that type of legal advice to the public. So that's something you're going to need to consult with your own legal counsel regarding. One thing that we've identified for ourselves is closed captioning. If you want to look into ensuring that your meetings, if you're doing video conference meetings, see if you can turn on closed captioning. That's one thing that we've identified for ourselves. But other than that, certainly that's something you want to consult with your legal counsel regarding. So remember, anyone is welcome to contact the Committee on Open Government's office by phone or by email with questions, whether you're a government employee, member of the public, media representative. That's our phone number. That's our office email address, the coog@dos.ny.gov, C-O-O-G, coog@dos.ny.gov. If you have questions about the Freedom of Information Law or Open Meetings Law generally, of course, but specifically regarding what we've talked about today regarding the use of video conferencing. What I'm going to do now is I'm going to turn off, do my stop sharing, and I'm going to go into the chat feature and start looking at questions that may have come in while we were talking regarding the use of video conferencing. Let me just get my chat feature up. There we go. First question that I received is, does a public hearing on a resolution to allow video conferencing under extraordinary circumstances have to be advertised a certain number of days ahead? So this is a good question, and the answer is going to depend on what type of public body is having the hearing. There's nothing in the open meetings law that talks about notice for public hearings. Certainly, if the hearing is being held by the public body itself, you're going to want to comply with the notice requirements of the open meetings law. But in addition, certainly local governments that are passing a local law are going to need to comply with the public hearing requirements regarding notification of hearing relating to a local law. And then in terms of other public bodies that merely need to pass a resolution, they're going to want to look to see if there are any specific statutes that govern hearings held by their body. So the short answer is I don't have an answer for you. I don't know what each public body is going to need to provide in terms of notice of their public hearing. We personally don't have, the Committee on Open Government doesn't have any requirements that specifically relate to it in terms of a hearing, not for this type of hearing anyway. So we had it published in the New York State the State Register. We put it up on our website, and we notified the public just like we would any other meeting, even though actually our public hearing was hosted by staff and not by the body itself. But still, we wanted to make sure, provide as much notice as possible regarding the hearing. Someone told me that I have my date wrong, that it's actually only extended through August 13th. Just take a quick peek. Not that I don't believe you, but I just want to take a quick peek and see. Oh, you know, that is what we have on our own website. For some reason, I had it in my head that it was the 14th, so I apologize for everybody. It's not August 14th, it's August 13th. Thank you. Next question is, when, if ever, do the public notice requirements of Section 1044 apply? So let's look at that. I'm going to pull it up. I know it's not going to show to you on the screen, but I want to read it out loud for everybody of what 1044 says. I think this is the provision of the statute that sort of is inconsistent with the new amendments, unfortunately. So Section 1044 states, if video conferencing is used to conduct a meeting, the public notice for the meeting shall inform the public that video conferencing will be used, identify the locations for the meeting, and state that the public has the right to attend the meeting at any of the locations. So this provision is going to come into play when you have multiple public locations, like the example that I gave regarding the Committee on Open Government. If you have multiple locations that are open to the public, members are not taking advantage of the extraordinary circumstances requirement. It's just that you have multiple public locations that are open to the public. 1044 is going to come into play there, where you need to provide the address of all of the open public locations and state that the public has the right to attend at any of those locations. I have a feeling that when the legislature was going through to make amendments to the open meetings law, they kind of forgot about this section, so it's not as clear as it should be. But that is the way we've interpreted it, is that 1044 only applies to situations, only applies to the open address, the open locations. If you have a member that's participating using extraordinary circumstances, their address does not need to be included in the public notice. I have a question regarding Chapter 1, while it remains in effect, asking whether it supersedes Section 103A of Chapter 56. It doesn't supersede Section 103. It's just that while Chapter 1 is in effect, you don't really need to worry about the new Section 103A of the Open Meetings Law. While Chapter 1 is in effect, if a public body wishes to have a fully remote meeting where all of its members, for example, are participating from their homes or offices, and all members of the public are prohibited from attending in person, then while Chapter 1 is in effect, it can do so, a public body can allow this regardless of extraordinary circumstances. When Chapter 1 expires, you can have meetings in the way that I described during the presentation. One, you can have multiple physical open locations that are connected to the use of video conferencing, or you can allow less than a quorum of your members to participate via video conferencing under extraordinary circumstances. No, you cannot. Once Chapter 1 expires, fully virtual meetings will no longer be permitted. Someone asked whether unabridged video recordings are considered to be minutes subject to the requirements of Section 106. Not exactly. Unabridged video recordings are considered to be minutes only for the sole purpose of posting. The new section of Section 106 of the Open Meetings Law requires that meeting minutes be posted to the agency website within 2 weeks of the meeting. And then it goes on to say, for purposes of this section, an unabridged video or audio recording or unabridged transcript can replace the meeting minutes, but it's only for the purposes of the posting requirement. So you still need to prepare minutes. All public bodies are still required to prepare minutes of their meetings in compliance with Section 106. But instead of posting those minutes to the website, if they would prefer to post an unabridged video or audio recording or an unabridged transcript, it can do that, but it still needs to prepare minutes as described in Section 106. Someone asked where we can get a copy of our PowerPoint. As I mentioned at the beginning of the program, it's available from our website. Just scroll down a little bit and you'll find a section that is labeled Training Material and Recordings. Someone goes on to say, so Chapter 1 is currently in effect. Chapter 56 comes into effect after the state of emergency. It's not so much that Chapter 56 isn't in effect. You can go ahead and start that process of for example, passing the resolution and establishing your procedures and all of that. You can get that ready to go. So Chapter 56 is already in effect. It's just that Chapter 1 suspends those requirements through the end of the declared disaster emergency. Someone is asking whether the rules apply to MPOs. I don't know what an MPO is. As I mentioned, someone asked about the presentation be available for us to utilize for people who missed it. As I have mentioned a couple of times already, the recordings are, the program's recorded and it will be available on our website under the section Training Materials and Recordings. Next question is, must there be a public hearing prior to a board adopting a resolution for extraordinary circumstances video conferencing? The answer to that is yes. The law is clear that it states that it must follow a public hearing. What does that hearing look like in terms of logistics? That's something that you need to talk to your legal counsel and see what requirements apply to public hearings for your entity. If a board member demonstrates extraordinary circumstances, must he or she list their home address as a meeting location for the public to attend in the meeting announcement? No, that is what extraordinary circumstances allows. That's why they pass this provision. They allow this provision for someone to participate from their home under extraordinary circumstances, or participate from their office under extraordinary circumstances. They can participate from a private location under extraordinary circumstances. That information does not need to be included in the notice. Their address doesn't need to be included in the notice, and it does not need to be open to the public. If the public body adopts a local law to allow for video conferencing when there are extraordinary circumstances, and there's a meeting where no members of the public body appear by video conference because there's no extraordinary circumstances, does the video conference option still have to be offered to the public for that meeting? The answer is no. If you know in advance that there will be no members participating via video conferencing, then you can hold that meeting just as you would have in February of 2020. 103A will not come into play. This goes on to say, so we know that under Chapter 56, public bodies will be able to use video conferencing providing there is an extenuating circumstances, and that recordings must be published on the entity's website. Are public bodies required to publish the public participation parts of the meeting? It's the entire meeting. That's Yes, the answer to that is yes. I cannot answer. Then it goes on to say, if so, what kind of liability does that create from municipalities that publish public comments that are disparaging, defamatory, or otherwise unprotected speech? We're talking about a meeting that occurred in the public setting. And you're talking about posting, not publishing, but posting a recording of a meeting that already occurred in a public setting. I can't provide advice regarding legal liability. That's something you need to talk about with your own legal counsel. But when we talk about recording a meeting, we're talking about recording the entire meeting, which obviously includes the public participation aspect. Another individual goes on to state, just to confirm, if you're using video conferencing to conduct a board meeting and members of the public can attend any location, and the provisions of Public Officers Section 103A do not apply. That is correct. If all of the locations from which members are participating, members of the public body are participating, are open to the public and have been included in the meeting notice, then Section 103A does not apply. Extraordinary circumstances provisions do not apply. That is correct. Sorry, I'm keep going here. Scrolling through some of the comments, I'm not quite sure I understand. If a public body had successfully resolved pre-pandemic and has been using video conferencing, can they continue to use this without a new resolution and following pre-pandemic rules? The new rule, Section 103A, expands the use of video conferencing. If the public body wants to use this expanded type of video conferencing for individuals under extraordinary circumstances where they're participating from a private, closed location, they need to pass a resolution. If a trustee will be on vacation for months and the public is permitted at that address and the remote address is published in the meeting notice, can they participate over video conference without a new resolution for extraordinary circumstances? In my opinion, yes. If you could do it pre-pandemic, you can do it now. Someone has explained to me that MPOs or metropolitan planning organizations, federally funded mandated transportation planning agency. This is something that I'm going to ask you to contact me directly about. If the only connection is to MPOs that they're federally funded, it's a question best handled directly with me instead of through the PowerPoint. I need to look into it. If a meeting used video conference for public attendance, but all trustees were attending from physical locations that were properly noticed and open to the public, conducted using video conference, does the meeting still need to be posted for 5 years? In my opinion, the answer to that is no. I'm not sure why you wouldn't just choose to do it anyway. Again, it's not an onerous requirement to post these things on a page like such as YouTube, but no, Section 103A only applies when you're using extraordinary circumstances video conferencing. Just keep going. If in public comment in person is allowed by a body, can they require the public participation via video to submit comments ahead of time? What the law requires is that if you are using this extraordinary circumstances video conferencing, you have to give the members of the public that are attending the meeting via video conferencing the same rights as those attending in person. The anticipated expiration date, the question is, what is the anticipated expiration date for the extraordinary circumstances provision? That was included in my PowerPoint. I believe it's June or July 2024. I apologize, off the top of my head, it's escaping me, but it's in the PowerPoint. If I go quiet, it's because I'm just skimming through comments. Someone says, clearly you have to have a public hearing for the local law allowing a remote meeting. Are you suggesting that after you use video conferencing after enactment of a local law that you have to have another public hearing prior to declare an emergency such that you'll have a remote meeting? I don't know what that means. I don't know what the process is for declaring a local disaster emergency. So that would be something that you need to talk to your own counsel about. You state that a local public body must have its own website. What if a local body is within a state agency? Can the local body post its materials on the agency's website? I don't see why not. I mean, if that's what you've always done. A local public body is generally considered, for example, a city, state, county, etc. So I'm not sure why it would be within a state agency. I think if you're talking about a public body that is hosted by a state agency, that's not the same as a local public body. Someone asked me to restate the distinction about New York City commissions that I mentioned in the presentation. Community boards. New York City has entities called community boards, and there's just a provision of the law that states that each community board is allowed to make its own decisions regarding the use of extraordinary circumstances video conferencing. The last question I have is, in order for a public entity to pass their own definition of extraordinary circumstances, must they pass a public resolution? Must they not be in person? Any action taken by a public body must occur within the context of an open meeting, whether that's currently under Chapter 1 or post-Chapter 1 where you have to be in person. That's up to you, but it has to, any action taken, any vote taken by a public body must occur within the context of a meeting held in compliance with the open meetings law. Definition of an extraordinary circumstances should be included either in your policy or your resolution. The resolution has to be passed by a public body within the context of a meeting held in compliance with the open meetings law. One more question appeared. After the meeting's initial public notice, 1 week prior, can the notice be updated to include additional physical addresses up until what point? The law states that meetings scheduled that are at least 1 week in advance must provide 72 hours notice of its of their meeting locations. So, in my opinion, you have to provide all locations at least 72 hours prior to the meeting. If you're having an emergency meeting that has been scheduled less than 1 week in advance, the law says that you must provide notice as soon as reasonably possible. Another question, so at our next upcoming meeting, our agency should pose and pass a resolution and invoke the extraordinary circumstances meeting provision to be applicable for the following meeting. The resolution, policy for passing a resolution, I mean, certainly the resolution must be, you have to have it, everyone, then someone is adding a note, is having a public hearing. You have to have a public hearing. Everybody has to have a public hearing. That public hearing can be part of an open meeting, but everyone has to have a public hearing in order to pass, prior to passing the resolution. You can have the public hearing in the first part of the meeting and then vote on the resolution in the second part of the meeting, but regardless, you have to have a public hearing. Hopefully have answered the questions. If not, you're always welcome to contact us directly. Someone may have mentioned that my PowerPoints that are up on the website might not be the most up-to-date version. I'll ask if they be added. I thought that they had been. I'll ask if they be that these be added to the materials. But all the information that was in the PowerPoint, just keep in mind that it's basically pulled directly from the statute. So if you look at section 103A of the open meetings law, you're going to see almost word for word the language that I included in the PowerPoint. All right. Well, thank you very much. I appreciate everyone who signed on today. I will get the program asked to be posted sometime within the next week. Have a great day and enjoy your summer. Thank you.